Bet he could. Each count of this 34-count indictment has a maximum penalty attached to it of 4 years. Well, that's 4 times 34. That's a maximum sentence, prison sentence of 136 years. Judge Mershon could sentence President Trump to jail for 136 years. Will he do that? Of course not. He won't. But could he sentence him to some incarceration? Yes, he could. Will he? Nobody knows. A lot of people are saying, nah, he won't. He'll just impose probation or a fine. But the truth is, sentencing is left very much open to the judge's discretion. It'll all be up to Judge Mershon, and nobody knows what he'll do at this time. Now, when is sentencing scheduled for? Well, Judge Mershon has set it for July 11th. Will something happen between then and now? Yes. Trump's team will ask for a judgment notwithstanding the verdict. They'll ask for Judge Mershon to throw out the jury's verdict and find Trump innocent despite the verdict. And Judge Mershon will turn that down. Then there will be arguments about what the sentence should be, briefing on both sides, possibly even a hearing. Then on July 11th, sentencing will be announced. And at that point, that triggers the Trump team's right to appeal. To what court would they appeal? Well, they would appeal to New York's appellate level court. And they would make arguments of the kind that I've summarized to you, and other arguments as well. And they will say, throw out this conviction. And after the appellate court rules, then the case could go up to New York's highest court, which is actually called the Court of Appeals, but it's New York's highest court. And after that, the case could go up to the Supreme Court. And ultimately, it might well go to the Supreme Court, where finally we will have a definitive, conclusive ruling on whether the conviction was constitutional or not. Of course, that would take years. And that's a problem here. Why is it a problem? It's a problem because the election will have taken place. And if this conviction is unlawful and unconstitutional, it could have an effect on that election. There are surveys, many polls, in which a substantial number of American voters say they will not vote for Trump if he is convicted of a felony. Many independents say that. Many Republicans even say that. If that's true, an unlawful conviction in this case could interfere with and in fact decide the outcome of the next election of the next president of the United States. Even if the conviction were reversed on appeal years later, that effect could not be undone. In legal terms, that's called irreparable harm. The irreparable harm, once again, is that a convicted felon could affect the election, could decide the election. And if so, then District Attorney Bragg and Judge Mershon will have unlawfully interfered with the election and decided the outcome of the next election through unconstitutional means. And no years-long appeal could have any effect on that. Well, is that where we are? So are we stuck with that possibility? Well, believe it or not, there is one other avenue that the Trump lawyers could pursue. They could sue in federal court and ask for an emergency temporary restraining order. Restraining order of what? Well, let me tell you something that you might not know. You've probably been reading in the press, if you've been reading about this case, that Trump is already a convicted felon. The jury has convicted him. He's a convicted felon. Well, guess what? That's not true. You're not a convicted felon because of a jury verdict. You're not convicted unless the judge enters a judgment of guilt against you. The judge still has the power, as I told you before, to throw out that verdict and enter a judgment of acquittal. You are not convicted until the judge enters that judgment of guilt. Now, in New York, it's very likely that Judge Mershon will enter that judgment of guilt against Trump on the same day that he issues sentencing. That'd be July 11th. So what would this federal case be about? In this federal action, Trump would sue District Attorney Bragg and other state actors and ask the judge, the federal judge, for an emergency temporary restraining order halting Judge Mershon from entering that judgment of guilt until the federal courts have had an opportunity to review and rule on the serious constitutional arguments that exist here. And let me tell you why I think that might be a very important thing to happen. Because going after criminally a former president of the United States and somebody who is running for president now, that's a very bad look for this country. It's an especially bad look when the folks bringing the case and the judge deciding it are members of the opposing political party. And it's an even worse look when the crime is so unclear that the state is hiding the ball about what the actual charges are right up through the trial and indeed into the trial. And even now, we don't know exactly what the jury found Trump guilty of. If you're going to go after a former president and somebody who's running for president now, the poll leading candidate, if you're a member of the other party and you're going to do that, you better have the goods. You better not be pursuing some novel legal theory where you have to hide the ball. It's not even clear what the charges are. That could be a very dangerous precedent for this country, a very bad and dangerous precedent. And that's why it's so important for a federal court to review the constitutionality of this prosecution and decide, was it constitutional, was it not? To achieve that, the only way to achieve that before the election takes place is for the Trump team to file an action in federal court and ask the federal court to temporarily hold off the entry of the judgment of guilt until the federal courts, and maybe the Supreme Court itself, can, on an emergency basis, adjudicate the likelihood of success of these constitutional arguments. If that doesn't happen, then that irreparable harm danger that I mentioned before, well, that's where we are. But if it does happen, the nation could get a ruling from the federal courts, even the Supreme Court of the United States, before the election takes place. And maybe that's what the nation needs, and maybe that's what the law requires here. So if I were Trump's lawyer, that's probably what I would do. I would run into federal court, file this action under Section 1983, and ask for a temporary emergency restraining order. Will Trump's lawyers do that? I have no idea. But that's what I would do. Could Trump